silence are commanded under penalty of law. God save the state and this honorable court. Please be seated.
Good morning and welcome to everyone. First matter on the docket is State of Louisiana versus Spell. Would counsel please stand and indicate their presence and who you are representing, and then we'll begin.
Whittenbrink here for Pastor Mark Anthony Spell.
Thank you, sir.
Darrel, Papillion, and Jennifer Morrow, Your Honor, for the state of Louisiana. Also, Your Honor, is Matthew Block, who is an amicus, and with the court's permission and indulgence, the state would yield 5 minutes of its time if the court would hear argument from Mr. Block.
Yes, thank you.
Your Honor, I would object to that. He moved to intervene in this case.
Excuse me, counsel, if you could remove the mask to talk.
Can't hear you.
Perfect.
Very much. Your Honor, I would object to that. The governor's counsel had moved to intervene in this case, and I thought that interveners would have the ability to actually have time for oral argument, not amicus. We could have had amicus. We have other amicus on our side as well.
Right. And we have historically always allowed, if time is yielded to an amicus, then they can argue. But so following our general custom, we will allow that because he's yielding a portion of his time. If you want to yield a portion of your time, you're welcome to do so. But let us proceed.
Thank you, Your Honor. Did not know the custom.
Okay, not a problem.
Good defendant.
Yeah, the amicus is simply a friend of the court. We'll consider it like any other amicus. And if, you know, we have read the amicus briefs, I assure you, on both sides very carefully. Thank you. Mr. Papillion, you ready to proceed? Are you going to yield the 5 minutes at the beginning or in rebuttal?
No ribbon.
Well, no, of the main argument. I'm so sorry. Yes. And Your Honor, if I might, the state in this instance is sort of the respondent. I'm happy to go first, but my understanding is that the defendant would go first. But
I believe you. Excuse me. I believe you're right.
I believe that's correct, Your Honor. This is a motion. We were here on a motion to
Okay, so you will.
take place that we would be the movers and be going first, and I'd also reserve 5 minutes of my time.
Okay, sure. Okay. Okay, please proceed then.
Begin.
Thank you, sir.
Good morning, Your Honors. Pastor Spell, Mark Anthony Spell, the defendant in this case, has been a pastor for many years. He was a pastor, his father's a pastor, and his father was a pastor of Life Tabernacle Church. Small church, I say a small church. It's 1,200 to 2,000 people in the church in central Louisiana. And those people come from all over the Baton Rouge area. It's probably one of the most diverse churches in the area. Pastor Spell goes to the inner city and gets children. He has many children. He has 36 buses that he travels, and he gets folks that can't afford transportation, gives them a ride to church. He feeds them the Word of God, and he feeds them an actual meal on Sunday, and then he takes them home. And he and his family have been doing that for over 62 years without fail, on every Sunday and then other occasions when the church is open. That tradition has not been halted, but it was attempted to be halted by the state when the governor issued his proclamations in March of 2020. March 31st of 2020, 6 citations were issued to the pastor for violating the governor's proclamations. The first proclamation was 30 JBE 2020, prohibited more than 50 people in the church. The second proclamation was 33 JBE 2020, prohibited more than 10 people appearing in the church. And Pastor Spell was cited and summoned to court. He was surveilled 24 hours a day, had cameras erected on his property and across the street from him to watch his home. As fruit of those surveillance videos, he was arrested again, put on house arrest, had an ankle bracelet. So it was a pretty severe intervention for Pastor Spell, holding church. Now, in this country, we don't jail people for holding church, but these violations carry jail penalties of 90 days per violation and $500 per instance. So he's facing more than a year in jail time if found guilty on all these violations. The First Amendment is not suspended during a pandemic. We believe that the governor had good intentions. We think that he was trying to do what he thought he should do in order to stem this pandemic, but we think that his actions were misguided and that they were wrong. Pastor Spell holds church, and right down the street from him is a Walmart. Over in town, there's Walmarts, Targets, all the exceptions that were made to the governor's proclamations. That's the problem with the proclamations. In the case of Roman Catholic Diocese,
Counsel, if they had shut everybody down, just nobody can go anywhere, that would be okay?
well, actually, I don't think that would be okay either. However, the point is, Your Honor, that if the Walmart's going to be wide open with no limitations, and you can be next to people, you can be spreading germs in the Walmart, you can be picking up items and putting them down and touching things, and all that was going on. You know, at the time, there were no mask rules back in March of 2020. Social distancing was not being mandatory. It was not being enforced in any kind of way. So if the purpose of the proclamation is to prevent disease, it doesn't make sense when thousands of people are going in and out of Walmart, but only 10 people can be in a cavernous church. The church is larger than this room.
And I'm looking at at 2020-30. It made an exception, I think, for airports, medical facilities, shopping centers, or malls.
That's right, Your Honor. Shopping centers, malls, the liquor stores were all open. Home Depot, Lowe's, so you could have any number of people in those.
In all of these places like Target, Walmart, Lowe's, you can buy cleaning supplies, sanitation supplies, aerosol to spray. You can do all those things there. Walmart's in my area anyway. Of course, I live in Thibodeau, so maybe we're different, but they have food in the Walmart. Target similarly. Am I shopping in the same Walmarts and Targets as they have in Central?
Absolutely, Judge, and I think Walmarts are pretty much everything you can find in most stores are going to be in a Walmart. So it wasn't just food and groceries, but you could buy jewelry, you could buy electronics, you could buy anything you want in a Walmart. The Institute of Transportation Engineers says that a Walmart supercenter gets 10,000 car visits a day. Now, in Baton Rouge, I know that's true. I don't know what's true out in Central, Your Honor. But they get a lot of visitors. If you're trying to protect people from disease, if it's really as serious as only 10 people being allowed to gather in a church, well, then there should be some kind of sequestration of those large places. In other words, perhaps the goods are brought to the street and people pick them up and go that way. You know, there are ways to handle it. In other words, it's got to be, I'm sorry, Your Honor?
You mentioned large. How many square feet is the church, Pastor Spell's church, and does that matter?
Well,
You said it was larger than this room, but this room's not very big for
No.
how many people you were talking about.
right, it's much larger, Your Honor. I don't know the square feet. I know that it's fire rated by the fire marshal to 1,250 people.
Yeah, let me.
That's just the main sanctuary.
Right.
There are campuses all over.
But let me ask you this, and,
Yes, Your Honor.
and you're telling me things, and both sides have very often quoted newspaper articles throughout their briefs.
Right.
And I don't know if y'all are willing to stipulate to the accuracy of newspaper articles or not. I dare say you would prefer not to.
Yeah, I would prefer not to. Judge, it's a habit we picked up in federal court. We had a federal court case, and they just allowed people to stack up exhibits with the petition or with their defense, and so I'm sorry.
So-called Brandeis briefs. But what we are looking for is not what you believe, but what we have in the record of this case.
Yes,
So all of this testimony that you're trying to get in the record about how large the church is any of that in the record at all?
No, Your Honor. It's not in the record.
Was there any evidence introduced?
There was
at this matter?
no evidence introduced in the motion to quash. That's
Okay,
correct.
so we don't know the size of the church, and we can't take judicial notice of such things.
That's correct.
We can't
That's correct.
go out and look at the church because we're a court of record. We can't accept evidence. So let's try to keep it to what we know
So,
in the record and what's in the record.
Yes,
Now, did anybody file the orders by the governor into the record? Is that part of the evidence that we have to look at?
I believe that the governor's proclamations are in the record, Your Honor. Yes, I do.
Okay.
I know that there
Were
are
they
attachments,
introduced?
at least either to the appendix or
And
they're
were they
attached-
introduced into evidence, or were they just,
No, I believe that they were introduced.
okay. You believe or you know?
I do not know as I'm standing here.
Thank you.
And I have another question, as relates to the difference in what's been pointed out in the governor's proclamation and as relates to a church. Isn't there a significant difference between gathering in an area and the types of areas that are identified which are more transitory? People are not there they're not next to each other for any period of time. They can stand next to one another, but the reality is in a church, you're gathering for a period of time.
Yes, Your Honor. So that was the argument in the case of Tandon versus Newsom and the case of Roman Catholic Diocese versus Cuomo. And those arguments were rejected by the court. They said that you can't say that the church always has people gathered together or that their people aren't gathered together in these other places. And to your question, Judge, it goes to the wording of the proclamation. It allows these exceptions that make these things possible. And Your Honor, Justice Griffin, I would say that if you've ever been in a Walmart on a Saturday morning and stood in line, I've stood in line a lot longer than my pastor can preach. So, and people were, at least at that time, neck and neck.
But
So
that all-
it's not in the record. Yes, you're
Yeah.
correct, Judge.
Yes,
But
if
just
you've
as an
ever-
example to talk about the Justice's question.
Counsel, if you've ever been to the food court at Lakeside Mall, there's a certain religious fervor that appears to set in there as well.
That's correct. And the elbows kind of swing sometimes at the Walmart line, and I've been in that a lot.
Well, let's get back to,
Yes, Your Honor.
this is all nice about the food mart and everything, but let's focus on the law here, because we're a court of law, obviously, and we have to
That's correct.
look at the law. Who has the burden in this case? And what is that burden?
Okay.
Does Pastor Spell, who brought the motion, have the burden? And if so, what is the standard of analysis and review?
Okay. So Pastor Stell did bring the motion. However,
It was a motion to quash.
motion to quash, and we brought the motion to say that these acts of the governor that were unconstitutional, the proclamations themselves and the way that they were applied were unconstitutional. However, I don't think that we have the burden of proving necessarily their unconstitutionality, because I think the state does have the burden to prove that in this case, as opposed to a normal statute which is passed by the legislature, which would carry a presumption of constitutionality.
Well, let's go through this then.
Yes, Your Honor.
He adopted these proclamations pursuant to statutory authority afforded by the legislature.
That's correct. However, the statutes say that the actions of the governor, in this case, have the force and effect of law. It's not the same as a law, And I would
Well,
submit to Your Honor.
Are you not splitting hairs there?
Well, no, I think
they
it's
have the
pretty-
force and effect of law, but they are not law.
For example, Judge, a police officer can tell me, stop, and I must obey that police officer at that point in time. That's a command with the force and effect of law, just like the governor's proclamation. Stop, okay? Now, I can disobey that order and accept the consequences of disobedience. However, when we come to court, we test that order. We see, was that actually a lawful order? Was it a constitutional order? And that's the difference in this case. You know, Your Honor's actually dealt with this before. I cited a couple of cases. Well, actually, they were cited by opposing counsel, State versus Pearson. This was about the looting statute. And in the looting statute, you had a statute. It's in Title 14, the Criminal Code. There was a specific section of the statute that said, if you're looting and the governor has declared an emergency, then you have an enhanced penalty. Now, this court said that that the governor's ability to declare an emergency is an administrative matter, and therefore the statute, given the penalties, was constitutional. However, they said if the governor were to have, I think they called it primary discretion. In other words, the governor can just declare something and have that be a law, that would be unconstitutional, be an unconstitutional delegation of power to the governor to be able to just say anything he wants.
Right, but no, they were specific about the health and safety of the public in this instance. Let me ask this question.
Yes, Your Honor.
Does the burden depend on whether we apply strict scrutiny or rational basis analysis?
Very much, Your Honor.
Okay, and so the question becomes, is this strictly a legal question based on the orders, or is there evidence we need to consider to make our determination?
Well, I think Your Honor can make the determination several different ways that it needs to be strict scrutiny, and I think you can do it based on the law. I don't think that you do need evidence, and I'll tell you why, if I may.
Go ahead.
So the first thing is the statute that we have in Louisiana that protects religious freedom, the Religious Freedom Preservation Act, requires that governmental actions that burden a constitutional right, they have to be done for a compelling reason and use the least restrictive means possible in order to be able to carry that burden. So that puts the burden on the government to say that that's what strict scrutiny is. That's how it's defined. Okay?
And do you have a cite for that?
Yes, I do, Your
Cite
Honor.
in your brief.
It's in the brief, but it's the Religious Preservation Act. It's in the brief, and it's in the reply brief as well. It's in one of the amicus briefs. But that absolutely means that the governor can't be exempt from strict scrutiny.
Okay.
And
Let me ask you this, and
Yes, sure.
I'll ask it this way, because this is from the Roman Catholic diocese case that you cited repeatedly, but this is a concurrence that says at the dawn of an emergency, and this is what we have. These orders were at the dawn of the emergency, at the dawn of the pandemic. And the opening days of COVID-19 outbreak plainly qualify. Public officials may not be able to craft precisely tailored rules. Time, information, and expertise may be in short supply. We have seen that happen, have we not, during the course of this pandemic? We have seen a lot of changes.
Certainly.
And those responsible for enforcement may lack the resources needed to administer rules that draw fine distinctions. Thus, at the outset of an emergency, it may be appropriate for courts to tolerate very blunt rules.
Well, the problem with that analysis, Judge, is that even though it was at the beginning of the pandemic, when you deal with a fundamental right, and in Louisiana, under the Louisiana Constitution and Louisiana law, religious exercise is of highest importance in our state. I mean, it's a very high fundamental right. Now, I'm not sure if I'm going into my rebuttal time or not.
Yes.
Okay.
You want to finish
I don't want to
it?
do that. I would like to save time for rebuttal. So,
Okay. Well, go ahead.
Okay.
You can either respond to the question
So
now, or you can...
I'll respond to it when I come back up, Judge.
Okay, that's fine.
Thank
Thank you.
Thank you, Your Honors. Darrel Papillion, I again would reserve 5 minutes for the amicus. Your Honors, it's interesting. Among the first words that we heard were Pastor Spell. They may have been the very first words. And we actually did not hear as much as I thought we would hear about the free exercise of religion. This case is not all that complicated in a time that I dare say none of us alive had experienced something like March of 2020. Our nation, our state, we are dealing with an essentially unprecedented pandemic. And during a very small window from the 17th to the 29th of March, the governor had issued orders, and on those days, on 6 occasions, Pastor Spell violated the orders. And you're right, there is no record. There was very little, if any, evidence introduced at the hearing, but Pastor Spell has made a point of repeatedly making clear that these rules would not apply to him, and he would hold church in an unlimited capacity. And you heard counsel say he would bus people in. We had a situation where a pastor is not just holding church, he's busing people into a church.
What about these people are not being forced to go? If they could stay home if they wanted to. Is the pastor responsible if somebody shows up for church?
No, Your Honor. I think the point there is that while many people throughout the state were following the law, and that really segues into the essential point. The law is not about one person, whether
Counsel, let me ask you this because you mentioned busing them in.
Yes.
And I thought I read in one of the orders where that was actually exempt activity, travel to and from the church.
That's true.
So there's nothing wrong with loading them up in a bus. It's just how many of them you can get into the door once you get there.
That's right.
We can congregate out in the parking lot. Am I right? Open space was another exemption.
Yes, Your Honor.
So, you know, there's some incongruity there in the comment that, well, we're going to load them all up and take them. Well, those were all exempt activities. You can load them up and dump them in the parking lot and let them celebrate.
Right. I think the issue is, I don't know that the law necessarily contemplated going to and from church in a bus, but certainly if you would comply with the law in a bus, you could comply. You could comply with the law in a bus. Sure.
I mean, under the guise of an emergency, I don't mean to demean the emergency or the proportions, but does it give you a pass to deconstruct our form of government? Are you allowed to operate without the checks and the balances that are inherent in our different branches? Are there some limits to what a governor can do under the guise of an emergency? Or do they just get to write the laws, and if you break it, you are criminally punished for it?
I think the answers would be no, absolutely, and no.
That's a good answer.
In that, yes, I mean, of course there are limits. And here, facing this pandemic, early on, going to and from a place of worship is a protected activity. It's fine. We learned, and anecdotally, again, there's very little in the way of record, but whole dioceses, no services for months, and people churched in other ways. People did lots of things in other ways. And yes, religion is extremely important, but when we are faced with something like we were faced with then, or maybe faced with again, if the governor of the state doesn't have the authority to issue an order, and we the people have no right to expect that people will follow that kind of an order in a reasonable way during an emergency, we are no longer a nation of laws. Yes.
Are we to take judicial notice of the emergency? Your opposing counsel indicated that there's been no evidence introduced into this record at all. Are we to take judicial notice of the existence of an emergency and define the parameters of that emergency by judicial notice in order to judge the efficacy of these orders?
I think this is a very reasonable court, and I would invite you to do that. Yes, it was an unprecedented pandemic.
Well, Ms. Papillion, doesn't the orders themselves indicate, you know, in I guess the where is part, or whereas portion, if you will, that, you know, what's the situation going on in the world? What's the situation going on in Louisiana?
Absolutely.
I presume the orders.
They do. All of them begin with a lot of whereases to explain why these very extraordinary measures are were being taken at that time.
But in any event, your position is we can take judicial notice of the ramifications of all this. Your opposing counsel seems to suggest we can take judicial notice. And for the people in the audience, this is a court of record. We don't have testimony here, and we're bound by what's in the trial record, right?
Yes, and we're on a writ, so there's, you know, we're in a different procedure.
And a motion to quash is a little bit different from other motions. But in any event, you're okay, you say, with us taking judicial notice of the whole sphere of this matter, going a little bit beyond the record? Yes or no?
I guess it depends, Your Honor, but I certainly would say that you could take judicial notice of the provisions in the governor's order, the description.
All those in evidence, we ask opposing counsel.
I don't believe they were introduced in evidence, Your Honor, because at the preliminary procedure that we were in on a motion to quash by the defendant, it was just argument, and obviously we didn't introduce the law or the orders, but the bills, and these are misdemeanors, of course, the bills state that he violated the specific orders of the governor.
Misdemeanors with a First Amendment
application,
so very serious.
Right. And the governor is not bringing these charges so that everybody understands that.
Yeah.
It seems to me that there's an issue of prematurity here. You even mentioned yourself the void in the record. Do we have a sufficiently developed record in order to make a determination whether or not there was an exercise of strict scrutiny, or does this case need to be further developed as opposed to just branching out on some sort of whim of taking judicial notice of things? But it seems to me that we need a more developed record as to the position taken by the pastor as well as the position taken by the governor. There's very little there for us to put our teeth into.
Your Honor, in response to that, I would say that the state in this instance, the district attorney in East Baton Rouge Parish, is looking for guidance from the court. In other words, are we to pursue a prosecution of this gentleman in violation of his religious rights? We don't want to do that. If the Supreme Court of our state can look at and take notice of what it needs to take notice of in a reasonable way, I know that's squishy and vague, and determine that these motions to quash should be overruled and the prosecution go forward, then fine. If it were to conclude that no, it shouldn't, then fine. The big issue, however, is what about next time? when there's a Category 5 hurricane and somebody wants to hold church in a different way, and the complaint is, well, you didn't tailor it so narrowly. As the Chief Justice mentioned, one of the dissents in the early cases explained, in the beginning, and this is all in the beginning, before the 1st of April, there's no charges after the 29th of March. Friday the 13th, everyone remembers, that's when it started. He's having church wide open. And so, back to your question, Justice Genovese, is yes, like with this, in a perfect world?
Why should it be any different than any other motion to quash as far as a developed record with proper testimony and evidence submitted, as opposed to just, and we don't give advisory opinions, and you know that, and most everyone does. The follow-up question, and I'll let you get to your argument, is even assuming this proclamation is fully constitutional and within the authority of the governor to issue, should it not be administered equally amongst religious organizations and secular organizations? Or is there a different standard for either the number of people here, the number of people there, the type of business you're in, the type of religion it is? Should it not be uniform across the board and apply equally to everyone?
I think the law is developing rather clearly that religion is entitled to.
Or should I say, is it appropriate to allow certain exemptions for certain organizations, but yet to hold the standard to the churches, whether it's Walmart or anybody else, Lowe's, Home Depot, whatever, if you're going to have a standard for them, should the standard not be the same as far as the number of people allowed in a certain area? Should it not be equal across the board?
In fairness, I believe that the free exercise of religion trumps your right to go to Walmart. And I say that in candor to the court as to what the law of our country appears to be. But again, when you're dealing with the time period that these emergency orders were issued, if we were looking at it now, knowing everything that we know now, I would submit, Your Honors, that there was perhaps a different way to do it, but at that time, it's clear. In fact, the law evolved after this was done. And so when, again, with the dissent that the Chief pointed to earlier, in the early days of the pandemic, we were faced with something that we had never been faced with before. And in this particular instance, what we had was one person. There are not legions of prosecutions in Baton Rouge of people, or anywhere else in the state, of people violating these orders.
In fact, this is a unique situation, wouldn't you agree?
It is, Your Honor.
A friend of mine said it was going into the pandemic in the early stages was like waking up in the middle of a Twilight Zone episode, and I think that's probably a pretty good description. Is there any significance to the fact that, as far as I know, trying to take that squishy judicial notice you were talking about, the legislature never and still hasn't convened itself in special session to address the issue, and particularly the types of things that the proclamation covered? Should we take any guidance from that?
I don't know what to make of that. No, I mean, I'm not trying to evade the question. I just, we'll take the law that they make.
It's an honest answer. It's a fair answer. But they never put the proclamation, they never put it into law. They never, as the representatives of the people, did that.
You want to defer that to Mr. Block?
I do. I just want to answer a question. I don't even remember whose it was, but someone asked if the governor was bringing the prosecution, and I would say no. The state of Louisiana, through the duly elected district attorney in East Baton Rouge Parish, is bringing this prosecution.
Let me ask you about that, because you're saying one person, and why was not number 11 or number 51 prosecuted?
The flagrant or the sort of unrepentant violation, I think, is a big issue here. And this person is not being singled out. It was like, I'll say it this way, and I want to leave Block some time.
Was his defiance just a little too public for y'all?
Say this again?
I said, was his defiance just a little too public
For the rule of law, Your Honor, for the rule of law. You know,
I don't want to cut into.
Yeah, that's okay, but I'll try to answer it.
I want you, before you sit down, to address the level of scrutiny, but back to Justice.
Yeah.
The defiance is not in the record. We've got a 50-person limit. Who's responsible for that? Why was not number 51 arrested?
Well, at various times it was as few as 10, but
Number 11.
But the charges were brought because it was in the hundreds, and it wasn't something. And
Sorry, you said because it was.
It was not a situation where a mistake was being made, or a little talking might make someone understand the importance of the order and the reason. It was, I am going to do what I want to do. And if the court finds that you can do that, then we will abide by that.
Well, we are left without a record to look at, so.
Counsel, if we are able to get to the substance of the issue, is the scrutiny level, is it strict scrutiny or is it rational basis?
It's higher than rational basis, Your Honor. Does it fall or go as far as strict scrutiny?
There is an intermediate level of scrutiny?
I think you have to say that it's strict scrutiny, and in this instance, I would submit we met that.
Mr. Papillion, I know you're conceding that, but it seems to me that the courts gave great deference early on. If you look at all the cases that went up, and then once things settled down and we had a handle on what was going on with the pandemic, then it becomes strict scrutiny. So I don't know if you concede
yes.
that, given what I read earlier.
I just want to be really candid to the yes, you know, there is a temporal element, and that's what we keep talking about in the beginning. And I'm curious as to a circumstance where you've got the implication of the freedom of exercise or freedom of religion principles, that it's some moving scale of scrutiny. I thought personally that once you implicate that right, then you apply a strict scrutiny test to it. And again, we've got much more study to do before we solve this riddle. The context of an emergency is important. I think that's some of what Mr. Block wants to talk to you about.
Okay.
Thank you.
Good morning, Mr. Chief Justice, members of the court. Matthew Block for Governor Edwards. I'll be very brief, both because I'm forced to be very brief, but also because I think the court has a very good grasp on these issues. Obviously, this is a criminal prosecution. The governor would normally not be a part or in any way interested in this, but if you look at the 4 issues presented for review by this court, by Pastor Spell, they all involve whether the governor's orders were legal or constitutional, and the governor obviously has a very compelling interest in making sure that those orders are considered, especially in the light of when they were issued. There's no question that one of the defining elements of this pandemic is that the facts on the ground have changed. And with it, the jurisprudence has changed. But it is, if you look at the cases that were cited repeatedly by Pastor Spell, the Tandon case, the Roman Catholic Diocese case, they were looking at 2 very different things, both different orders that were much more targeted to and at religion, and also different timing, in that it is, I suspect, a very rare situation where someone gets up from this podium and speaks mainly of a dissent in a case, but probably the most instructive part is the Chief Justice has already recognized in asking questions about the Calvary Chapel case, the dissent by Justice Alito, which was joined by Justice Kavanaugh and Justice Thomas, pointed exactly to that issue of frankly, the chaos in those early days in March. These orders were issued within days, less than 2 weeks, of the emergency being declared.
Mr. Block, does this, at the end of the day, target religion in any way, shape, or form, or is it really targeting time and place, location and situs, if he would have held these services in the parking lot, would there be any problem?
Your Honor, I mean, that's exactly the point. The churches, despite what has been argued in this case, churches were never closed.
Apparently, they could have held it at the church at the mall.
No, well, Your Honor, that's actually not the case. In that the number 33, the second order, did close malls. So, but one of the things that happened in those early days, and it was almost like Justice Gorsuch was having a view into the room where these decisions were being made. Things changed so dramatically from day to day. So shopping malls were allowed to,
You can finish your answer.
And I have a question after that, please.
Shopping malls were allowed to stay open initially, not food courts in shopping malls, but shopping malls were allowed to stay open. That changed within a matter of days because of the growing concerns. But the concern was always about gatherings, about people getting together for periods of time. That was what the public health advice unanimously said was the biggest concern. That's why theaters, which if we look at comparable activities, theaters were closed. Activities where people were going to be gathered for significant periods of time were closed. Religious services were treated differently in that they were treated more favorably because they were never closed. The gathering sizes were restricted, and they were treated more favorably, unlike California and New York, where they were treated less favorably. That was a purposeful intention of the governor in a part of these orders.
Mr. Block, isn't it a significant distinction here that this is a criminal case versus where liberty interests are at issue, in addition to the First Amendment, right, versus some of the cases that we have been cited, which are civil cases?
That's correct.
I mean, doesn't that heighten the level of, I hate to say scrutiny, but heighten the level of our review and our concerns? Any comment on that?
I wear a lot of hats, one of which is not as a criminal lawyer, so I will defer to both the counsel who are seated behind me as to how this affects a criminal prosecution. But obviously the question of whether the orders were constitutional, which is the issues before the court, those remain the same whether or not it was an injunction trying to prevent the order from being held in effect, or whether or not it was used as a basis for a criminal prosecution.
All right, and by the way, you wear your multiple hats well. Thank you for your work.
I do my best, Your Honor.
Thank you.
Thank you, Mr. Block.
Thank you very much.
Counsel, don't feel deprived because he got a few more minutes, because I will give you an extra minute.
Thank you, Your
to
Honor.
for rebuttal. We also allow, if a justice asks a question past the time frame, because sometimes we have hard time squeezing in questions because
Everybody's interested in what we're talking about.
Right, exactly. So it's more of a reflection on us trying to come to an understanding so that we can make the proper decision. So, Madam Clerk, if you would afford counsel another minute for rebuttal, since Mr. Block went over in answering questions. He didn't do it purposely.
Thank you, Your Honor.
Thank you.
That very much.
Please
so
proceed.
Your question was about the statute, the Preservation of Religious Freedom Act, and that's Title 13, 5231 through 5242. And that would require the application of strict scrutiny, and I do appreciate the candor of counsel with regard to strict scrutiny, because I think there's absolutely no way to get out of it in this case. And in emergency or no emergency, Justice Crichton, I think that you were correct about the other cases that we've cited have all been civil cases. They're about whether or not damages are going to apply. They're about whether or not you can get an injunction. But this is about the liberty of an individual, and I think that you do have to look at that a little bit differently.
Let me just say I appreciate Mr. Papillon's candor also, but yet I still have some reservations on whether or not that candor is appropriate. But you know, we're going to research all of this very carefully, I assure you. The scrutiny comes in because of there's no evidence in the record, and so it relates to the burden of proof also.
So, and what I would say, Judge, is I would think that Your Honors could take judicial notice of the actual proclamations of the governor and the words of those proclamations and how they apply in real life.
I concur in those remarks.
And when you're talking about exceptions, office buildings were an exception to the 50-person rule, to the 10-person rule. You just had to be an essential worker. Now, again, not evidence in the record, but obviously, they did not make the church. If they made the church's business essential, then there wouldn't have been any limit to the numerical people that could be in the building. In office buildings, you have large office buildings with a bunch of lawyers. I mean, anyway.
But again,
the wording of it.
Yeah, I understand, and the dissent that I read speaks to some of those problems. They are staying up past midnight writing all of these things, trying to figure out, what we're going to do. And we were faced with some of those same issues
Certainly.
in the court, whether or not to call off jury trials. But isn't this about time and, I mean, more about place? Because, they were all manner and mode of which religious services were delivered in this pandemic.
That's correct, Judge. And people asked Pastor Spell to hold his church services in a different way. And but the problem is that, if the government is telling you to hold your church service a different way, well, then you get into sort of an establishment clause problem. You become too entangled of telling people how they're going to hold church. I think there are cases on that, but they weren't cited.
I don't know.
It wasn't brought up. But I do think that if you tell someone you must do this by video, as for example, I think that that's just not permissible for the government to do.
They're not telling them to do it by video. They're telling them just don't get everybody into the church where there is, I presume, preaching and there's singing and.
So and what I would say, Your Honor, is that they can't make those exceptions that they make and not have them apply to the churches.
Are you familiar with the? There is a aphorism attributed variously to Justice Holmes and Lincoln and John Stuart Mills, and I've rephrased it slightly. The right to swing my fist ends where another's nose begins.
That's correct. I have heard that.
Is that quote apropos here in a highly transmittable and lethal virus, which is spread by airborne droplets transmitted microscopically, in effect through respiratory orifices,
what I would say
such as the nose and the mouth?
Is that you can't assume that the people in the church are stupider than people in the Walmart. You can't assume that people in the church won't take the same precautions that people in an office building, people in the airport, people at the Lowe's. You can't assume that church folks won't do what they should do in the church. And you can't have a regulation that applies and gives all these other folks opportunity to do what they want to do, but say you can only have 10 people in your church.
But there's food in Walmart, there's disinfectants, there's all these things there that allow people to.
It belies what the governor has told us about the pandemic. The actions of the government belie the seriousness of it.
You can take your time and answer the question.
Truly that serious, truly that contagious, truly that decimating. I would submit to Your Honors, all of you, that actually the government actions in this case are unprecedented. We've had pandemics in the past. We haven't quarantined well people. We haven't done the actions that have been taken in the government in this case. And this court is the place where constitutional freedoms are upheld. There's precedent. Civil War. Abraham Lincoln thought it was essential to suspend writ of habeas corpus. And afterward, the court came back and said, no, that's not proper. In the case of Youngstown Steel, President Eisenhower said, we're going to seize that steel mill because we can't run out of steel. We're in the middle of a war. And the court came back and said, no, you can't violate the Constitution even in a horrible war where people are being killed. And the pandemic is the same. You can't suspend everybody's freedoms. And even the timeliness, Judge, is you've got to say, you've got to protect the freedoms that we have.
Thank you very much.
Thank you, Your Honor.
Thank you. You both did a magnificent job. All of you did a magnificent job. And now we're left to make a very difficult decision. Thank you. Thank you.
Justice Griffin, good to see you up there.
On the docket is Martin versus Thomas. I understand there has been some amicuses that some time has been yielded to here just to demonstrate that the custom that we utilize is alive and well and applied equally to everyone.
My name is Brennan Hussey. I represent the defendants, National Liability and Fire Insurance Company, Greer Logging, and Rodney Thomas. I would like to introduce Hunter Crawford, with my law firm, and we would yield 10 minutes of our time to Doug Williams and to Skip Phillips. Mr. Phillips wrote the amicus on behalf of the Louisiana Association of Defense Counsel. Mr. Williams wrote an amicus brief on behalf of the Louisiana Motor Transport Association as well as the American Truckers Associations. Thank you. And we would request that 10 minutes of our time at the end that I be allowed to yield 2 minutes of my time to their argument. Thank you.
Good morning. I'm Cole Sarton. I represent the plaintiff relator Reginald Martin. This is Mr. Todd Townsend and Ms. Mary Smith, and we are yielding 7 minutes of our time at the end of the main argument to Mr. Townsley on behalf of the Louisiana Association of Justice who filed an amicus brief this matter. At the end, we are reserving 7 minutes of rebuttal.
Okay, so you're not giving him your rebuttal time. You're yielding 7 minutes of your time, your initial time, right?
Yes, sir.
Okay. All right. Let's begin.
May it please the court. Under Louisiana law, employers have a duty to hire qualified drivers. They have a duty to train, supervise, and retain these drivers, and they have a duty to not entrust their vehicles to incompetent drivers. Employers